The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning, everyone. Welcome to the first of this week's Supreme Court docket. I would now ask Mr. Doug Shima, the clerk of the appellate court, to please call this morning's case.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Monday, October 25th, 2021 consists of one case. Appeal number 122271, State of Kansas versus Emond S. Gulley, Sedgwick County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
May it please the court, Emond appears through counsel Jacob Nowak of the Appellate Defender Office, present and ready for argument.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Thank you, counsel. Mr. Nowak, you may proceed with your argument.
Thank you. This case comes before the court today on original jurisdiction from Emond's direct appeals of his convictions and sentencings for first-degree premeditated murder and aggravated robbery. Emond was 15 years old at the time these offenses were committed, but based on the nature of the case proceeded, on how the case proceeded below, neither the jury nor the judge ever had to meaningfully consider that factor. The jury was effectively precluded from considering Emond's youth and how the impetuosity and rashness of youth could have played a role in the underlying events when the district court failed to give a lesser included instruction of voluntary manslaughter, which resulted in Emond being convicted of first-degree premeditated murder, placing him in a subject to a mandatory sentencing scheme, which precluded the court from considering youth, attendant characteristics, or individual circumstances in any meaningful way prior to imposing a sentence of life without parole for 618 months or 51 and a half years. I recognize that we have a lot to get to on sentencing. I'll advise the court from the outset that unless there's questions, I intend to submit issues 2 and 3 on the briefing, but I would like to start with issue 1, which was the district court's failure to instruct on the lesser included voluntary manslaughter. District court has a duty to instruct on the lesser included when it's factually and legally appropriate. In this case, the voluntary manslaughter is the knowing killing of a human being on a sudden quarrel or heat of passion, or in the heat of passion. Here, the facts demonstrate that it was factually appropriate. Emond was spending the day at his cousin's girlfriend's house when his friend TC messaged him to see if he and 2 other juveniles could come over and smoke marijuana with him. Those individuals did come over. Those 2 juveniles ended up acting as adverse witnesses against Emond at trial, pointing to him as the person who killed TC. And despite that, and despite them providing testimony of the whole day, we do not have evidence of an ongoing dispute between Emond and TC. In fact, throughout that day, aside from a robbery that Emond took no part of, there is no evidence of anything out of the ordinary other than that robbery, which is primarily relevant because TC took the gun from that robbery and placed it in his waistband for all relevant portions of the day. Other than that, they spent the day smoking marijuana and listening to music. Late in the evening, TC left the house with another individual who the adverse witnesses claimed was Emond at trial. TC was going to visit his cousin. Outside of his cousin's house, his cousin heard 2 things: a loud argument and gunfire. We have evidence of the video evidence, although not audio evidence, of that shooting was produced at trial. It states Exhibit 102, shows some important things. It shows these 2 individuals walking together, but right before the shooting, the secondary individual, not TC, is walking directly away from TC. They have begun to part ways. We then see TC looking towards that individual, and unfortunately, we do not have audio of that event, but corroborated with the evidence provided by TC's cousin, an argument took place near or at that moment. We then see that individual change course, walk towards TC, grab the gun from his waistband, shoot him multiple times, although in a brief period over the course of 3 seconds, and then TC get up, run away. The other individual not give chase, but in fact, run in the opposite direction.
Where's the provocation here, Mr. Nowak? I've looked at the record, looked at the video multiple times. I just don't see any kind of evidence of any kind of provocation or any kind of sudden quarrel or anything happening here.
The evidence of the provocation comes in directly from Ms. Ruiz's testimony about hearing the argument directly before the gunfire. The video, that is not of the world's greatest quality, shows TC looking at this individual as he's walking away from him. In light most favorable to the defense, that is where the provocation takes place. That is where the argument takes place that compelled this juvenile to succumb to a heat of passion and turn around and change course. That is,
I'm sorry, go ahead and complete your answer.
well, that is where we see the only actual motivation for this killing, which the state at the beginning of its closing arguments pretty much concedes when it says, we're not going to be able to tell you why, but you don't need to find why, which is only true because we don't have the instruction for voluntary manslaughter.
Is it true then that what you were arguing is that there had to be words exchanged? And so your argument relies on verbal argument?
Correct, that there were words exchanged. We had evidence of an argument, but we have.
To say that that's adequate provocation for the instruction, wouldn't we have to overturn a very long line of cases that say words are not sufficient?
Well, it depends on how we clarify mere words being sufficient. Overturn, I think, is a strong indication because we have those cases have always looked towards the suddenness of the argument and whether or not there's an ongoing dispute. So in that light, we have suddenness. We have no ongoing dispute. We have a brevity of an offense in addition to these things, in addition to these words. We also have a lack of any other explanation. And we're dealing with a juvenile who essentially through their intrinsic traits are hypersensitive to succumbing to a heat of passion. And for all those reasons, I believe we have more than mere words as contemplated by that line of case law.
Counsel, even as to the words, didn't the witness say, withdraw that and say she thought it was only a dream in which she heard the arguments?
I wouldn't characterize it as a full-blown recantation of her testimony. It's more of a pondering about whether or not, because the witness was attempting to fall asleep. But the reality is, if we're viewing that line of testimony in light most favorable to the defense, for our purpose, there was an argument. That was a question for the jury to consider, to weigh that evidence, who had actually seen Ms. Ruiz testify and give credit to those statements one way or the other.
Mr. Nowak, it looks like you only have 5 minutes left. I'd like to jump to the most recent case on the juvenile offender in the United States Supreme Court, which is the Jones case. How does that affect your argument here?
As it pertains to Emond, it does not impact it largely. It mostly would impact the remedy upon remand, because what Jones does is clarifies what is required for Miller v. Alabama. What's required is discretionary sentencing. It doesn't tell us when those protections are triggered. Montgomery does a better job of telling us when those protections are triggered. Montgomery says that life without parole is constitutionally prohibited for all juveniles, but for the rarest of offenders who represent permanent incorrigibility. And the discretionary sentencing is necessary to separate those two classes. Now, we know now with Mississippi v. Jones that discretionary sentencing, as opposed to an actual finding of permanent incorrigibility, is all that's necessary. But when we have a statute that doesn't provide for any sort of discretionary sentencing, we need to have the statute comply with Montgomery, comply with Miller on its own. And when we have harsh sentence lengths where it is conceivable, if not likely, that children who have them imposed against them will die or will not survive those sentence lengths, then that becomes something where it triggers Miller.
Would you address?
I'm having trouble getting past, to get to your argument, to get past the language in 2166-23 that reads, the defendant will be convicted, and I'm going to paraphrase here, to the hard 50. But then this is a direct quotation. Unless the sentencing judge finds substantial and compelling reasons. Why doesn't that put us in discretion land?
Why doesn't that put us in discretionary? Well,
Yes.
under the sentence Emond was sentenced to, he did not have discretion. He could not find substantial and compelling reasons. But if he were to be in a C and I box, it becomes a little bit finer of a question.
And
What
so
we
you're,
know,
you're relying on the B, the subsection B of 6623 to say no discretion.
correct. If they fall within a sentence in grid box based on their criminal history score that would exceed 600 months, the district court no longer has discretion to depart down to a Part 25 sentence.
What about the discretion that the grid box allows? And that's the question that we had that the court wanted you to address. It just seems to me, and a couple of things here are my observations, is that once you move to the grid box with a criminal history B, there is discretion for the standard range, the aggravated range, and the mitigated range, which once you're up in this kind of a level is up to 6 years from the high end to the low end. Isn't that then a discretionary function? And one, answer that question. And then two, the other question I have anyway, is it appears to me in looking at this is that no one assumed that there was any discretion once you're in the grid box, that you had to go to 618 months. That appears to me what the journal entry reflects. The brief discussion that was had with counsel at sentencing seems to imply that. Address those two questions for me.
Of course, I believe that is a fair interpretation of the record, that everyone below assumed that 618 months was the only applicable sentencing range. That said, I'm not certain I agree that the statute itself allows for that level of discretion. I understand the language that we're coming from that says in such case, the defendant is required to serve a mandatory minimum term equal to the sentence established for a severity level 1 crime, which would seem to place us in that box. But that interpretation also needs to satisfy our principles of statutory interpretation. Most notably, we have a potential absurd result in the doctrine of constitutional avoidance, because what we're doing is placing individuals of similar circumstances in different positions. And I'm not sure there's a rational basis for saying that an A or a B criminal history score should be subject to a lower criminal or sentence.
Can the rationale be that once you're in the grid box, you have no discretion to depart downward? That to me seems to be a rational basis for allowing some discretion, not a whole lot, but a little bit of 6 years. Because once you're in the grid box under this statute, you can't depart to a hard 25 or to whatever, a 25. You have to impose the sentence that is in the grid box. So that seems to me it's not absurd. To me, that's a rational basis or a reason to allow some discretion in the grid box, because you can't go any lower than, what is it, 500 and some, I can't remember the exact, but the minimum is a good deal less than the maximum.
Before I begin, Chief Justice, I see my time has expired. May I have leave to answer Justice Rosen's question?
Yes.
So that's true. On the one hand, it does appear to present a rational basis in that there is no departure, but we know that substantial and compelling reasons are not nothing. Those are facts that have to be found. And so when that's not found, you've got a situation where the person with the higher criminal history is arguably in the better position. But that said, our position is, even if that discretion exists, it does not present a meaningful opportunity of release. That discretion is still going to require a juvenile in any situation to be subjected to incarceration for the remainder of their childhood, the remainder of their adult life, and they'll be released as an elder adult. And they went in as a child, so they will not have the functional skills to be prepared for that, the complexity that stage of life brings.
I'm having trouble trying to quantify all these arguments that are made, talking about a meaningful point in the juvenile's life or a meaningful opportunity for parole. I mean, where does that line get drawn?
Right. There are, in my view, two ways to look at that. There is the conceptual approach that you're talking about, a meaningful point that we can look at. And our position on that is that it needs to be a point where, since we've recognized elder adulthood is a stage where people are fundamentally more vulnerable, it needs to be a point that's going to allow the juvenile, the child, time to assimilate back into society, to prepare that, to get complete an education, to get work history, to get financial savings, to establish a familial unit, learn how health insurance, housing, utilities, all those things work, learn how the technology of that day and age is going to work. That's a conceptual approach. We don't know exactly where that age is. It's probably around 45 to 50, somewhere in that range, release to actually give them time to meaningfully reassimilate. But we don't need to decide exact age based on the statute that's in front of us, because we have a hard 50, which isn't going to allow for it, and a hard 25, which would. It's the same result we reach if we look towards an actuarial approach, and we start to look at what type of life expectancy can we expect? Because that's not the exact question we can ask. Because Montgomery found that this was constitutionally prohibited for all juveniles except for the rarest of offenders, and that discretionary sentencing was necessary to get us there. But we don't have discretionary sentencing, so our sentence length has to do it on its own. And we can look at a hard 50 and say, we're not certain that the overwhelming majority of juveniles are going to survive this, which is the question we need to ask. But we're certain with a hard 25 they would. Now, if the legislature wants to change that and push the envelope, we have to narrow it down.
Where do all of those sort of tests and standards that you just
Where all those tests, they come from the direct language of Miller and Montgomery, which is one, that juvenile is entitled, the state is required to provide for a meaningful opportunity of release for all but the rarest of offenders for whom demonstrate permanent incorrigibility. Montgomery made Miller substantive. They made this a categorical bar for the vast majority of juveniles, and that we need discretionary sentencing to get there. It's just a reasonable interpretation of those lines. Some courts have taken an actuarial approach. Some courts have taken more of a conceptual approach like Washington has. Either is fine, and either gets us roughly to the same point, that somewhere around the age of 45 to 50, if that's where your release date is, it starts to become a question of whether or not it's permissible. Here, our release date is in the 60s, mid 60s. We can look at that either from a conceptual or actuarial approach and know it's constitutionally impermissible. And the answer to that is just make it discretionary.
I want to circle back to the statutory interpretation questions I was asking.
Right.
The next question I was going to ask, and I think you've talked around this, but I decided maybe I should ask the question directly so that it gives you the opportunity to answer directly. In B, which we were focusing on, it refers to sentencing within the sentencing range. Anytime the statute uses the word sentencing range, how can that be non-discretionary in terms of application of the U.S. Supreme Court case law that establishes discretion as a threshold under Mississippi versus Jones?
Right. Anytime we're talking about a sentencing range, we are talking about discretion. But are we talking about the discretion to impose a meaningful opportunity of release? When we're talking about Emond, whose total aggregate sentence hasn't been released in his 80s, the reduction of 5 years, I believe, is that going to be the difference that makes a meaningful opportunity of release? Or even if we just look at it from his mandatory sentence length, it's release at age 66 currently, or it's at release after 51 years, which if you impose that on a 15-year-old, is going to be released at age 66. Or if we reduce that by 5 years, it's released at age 61. Either way, he's being released as an elder adult, as defined by our statutes. He's about, even at its most benign form, he's about to receive a Social Security check upon release, which is the federal government's implicit recognition that he's not going to be able to independently support himself. So that doesn't provide for meaningful opportunity of release. I acknowledge that if you interpret it to mean that entire grid block, that is discretionary, but it's not a discretionary decision to impose a low enough sentence that it will get us out of Miller.
Other questions?
I think Jones from April of this year is more devastating to your argument than you're letting on. But even before Jones, the notion was that we had to take into consideration the what they call it in Miller, the permanently incorrigible nature of the juvenile defendant. And hasn't the legislature done that by saying that if we get a juvenile in front of us that's already has enough criminal history that they're at a B, then the hard 50 is the approach, a hard 50 or even that small discretion in between there. That would seem to, if we let the legislature make those kind of decisions, it seems to me that we've even met Miller, and Miller's like more loosey-goosey language, I would call it. Does that make sense?
It does. I disagree, because we're still talking about criminal history that was built, why this child was a child, why they had this impetuous nature, why they were unable to remove themselves from the harshness of their environment, and why their brain was fundamentally undeveloped. So that criminal history on its own can't de facto determine that they're permanently incorrigible. That's a decision we need to make based on the individual traits of the offender and the underlying traits of the offense. That requires full discretionary sentencing for us to really dive into that. You won't be able to get it through criminal history alone. For instance, in this case, those offenses occurred shortly after the offense, when he was under an immense amount of stress in custody. I don't think that can show permanent incorrigibility.
Just briefly to piggyback on Justice Biles' questions, in this case, there was obviously a motion for adult prosecution. And I appreciate that Miller says that would not suffice to satisfy the juvenile and its attendant circumstances and all that inquiry that must be made. But when I look at the transcript here, it seems to me that the court did weigh all of the factors, which included criminal history, and also included psychological information that was from an evaluation that took into the weighing and balancing. What more would happen for your client when that is taken into account at, let's say, a sentencing? What more information would be there than what was, if the procedure here used in Kansas didn't satisfy it, what more would be needed?
Well, as far as what more would have been present, is the person making that determination would have known what Emond's criminal history was. It was not known that he was going to be a criminal history score B at that time. He had not pled to that cases. So that discretionary decision, to the extent it was one, did not encapsulate that he was not going to have a meaningful opportunity for release. That's why Miller talks about, we can't make this decision at the early stages of the proceeding. And we can't, it's not a true decision when we're talking about extremes. That person's choice was to have Emond sentenced essentially to release at 23 years old or subject him to adult prosecution. That's not a true discretionary choice, because it's a choice between extremes. It's going to be selected for adult prosecution.
Any more questions? Okay, thank you, counsel. Mr. Gillette?
Thank you, Your Honor, and may it please the court. I will briefly address issue 1 and then turn my focus obviously to the constitutional sentencing question. Regarding issue 1, the state's first argument about the lack of a heat of passion voluntary manslaughter lesser included instruction here is that this was if it's error, even assuming that there's some error, it was invited in this case. I don't think that the record could be any more clear when we have a defense attorney that stands up and says, quote, "Candidly, Judge, I think the court has to give any lesser that it believes is applicable. Initially, we requested manslaughter, but based on the facts, I can't, in good faith, ask the court to give the instruction as it doesn't apply." This is distinguishable from the Soto case that my colleague on the other side cites in his brief, because Specifically in this case, the defendant's advocacy was linked directly to any supposed adverse impact. As noted in the Coble case, that in and of itself, it constitutes invited error. It could not be any more clear. The defense attorney referenced the evidence and his ethical duty to the court and invited the court to not give this lesser included instruction. Moreover, that invitation was also linked to their all or nothing defense strategy. The strategy at trial and the defendant's own testimony was that somebody else committed this crime. It was not him. Thus, an all or nothing defense. As far as the giving,
let me just is saying I can't ask the court to give an instruction the same as saying I don't want the instruction? I mean, I know it's a fine line, Mr. Gillette, but isn't that what we kind of get to in Soto?
I think that it is a bit of a fine line. The problem that the defense has in this case, though, is that they initially did request the voluntary manslaughter and then they changed their position. And I think that change of position is easily equated with not requesting the instruction here. But even if this court declines to imply invited error, the state continues to assert that this instruction was not factually appropriate either. The defense's entire argument is based on their interpretation of Miss Ruiz's testimony. And when you look at the transcript, volume 9, pages 39 through, I think, 41, I think that, Justice Wilson, you hit the nail on the head. We have what began as a very ambiguous statement that, quote, I heard arguing outside of my bedroom window, but at the time I was trying to fall asleep. I was in a deep sleep. So I thought I was dreaming. And then she clarified that through subsequent questioning to be, when she was asked, is that about gunshots? Is that what woke you up, or were you already awake when you heard the gunshots? No, that's what woke me up. So I don't think that this would have been a factually appropriate instruction. And again, the defendant himself never claimed that there was any kind of an argument, only words that were exchanged, which flows directly into the fact that this was not a legally appropriate instruction either. As Justice Lukert, you indicated, mere words cannot alone suffice to justify heat of passion voluntary manslaughter instruction. That's all that there's evidence of in this case. That's it. Words, potentially, maybe mere words. So that instruction would not have been legally appropriate. Finally, if there was error here, the state would point out again that this would have been a completely harmless error. This court would have to apply clear error review. The defendant cannot convince this court that the jury would have reached a different verdict had the instruction error not occurred. A, because this crime was clearly of a higher degree. This isn't a voluntary manslaughter case. The defendant ran up behind a 17-year-old friend, purported friend, that he claimed he didn't know, but had spent the entire day with and was going to go get more marijuana with, runs up behind him, takes a gun, shoots him in the back, shoots him once he's down on the ground, and then runs away and begins to concoct a web of stories that evolves multiple times over time to his friends, to detectives, to his testimony on the stand. This crime was clearly of a higher degree. The skip rule also applies, as the state notes in its brief. If there are no further questions on that, I would also submit issues 2 and 3 on the brief. And then we can turn to the question of the constitutionality of the defendant's sentence.
Could you first address the questions the court had regarding the use of the grid box and whether there's discretion? Because if there is, it seems to me, and what Mr. Nowak stated in his position is that the court was assuming that the aggravated range in the grid box was just presumed, and that's the only discretion the court had. And if that is not correct, what do we do? Because don't we have to have a legally imposed sentence before we deal with anything? I mean, it just seems to me that it's very significant and important in this case. And it might be a distinction without a difference once we get down to it, but don't we have to have an appropriately imposed sentence?
I think that is accurate. But there are two things that I would like to point out. And if I may, Justice Rosen, I would begin with my preservation argument. And then I will turn directly to your questions. I know this court, based on its special questions, may be inclined to consider this issue preserved. However, the state continues to assert that it's not. The defendant only ever asserted the first exception to the rule that precludes raising new issues for the first time on appeal. But implicit in his argument is that his claim does not fit within that exception. Had he asserted the second exception, we may have a little bit of a different argument to be made here about this matter being preserved, but we don't. So I don't think that it's preserved in the first instance. Now, turning to the court's special questions, I've heard questions from Justice Rosen and Justice Biles, and I think that today about how KSA 60 or 216620 is to be interpreted, specifically C1B. That is obviously the statute that resulted in the defendant's sentence in this case because of his criminal history B. I think that there are probably two reasonable ways to interpret this statute based on the different questions that I've heard. I think that you've touched on those different ways. Number one, if you put the defendant in the grid box, maybe the court has discretion for all of those numbers in the grid box, or perhaps number two, and I think the more reasonable interpretation is that the court's discretion would be for anywhere from the hard 50, 600 months, up to the maximum sentence allowed within the grid box. And I think that that's the more reasonable interpretation of this statute, respectively, because the statute is intended to treat those individuals with a criminal history A or B, a history that is so violent that their sentence, and they are the kind of individual that merits a harsher sentence than the standard hard 50. It wouldn't make sense necessarily to go below the hard 50.
Counsel, I have a two-part question. First of all, the same sentence would apply to a 60-year-old convicted as applies to a 15-year-old convicted. Does that make a difference, that the 15-year-old would have to serve a much larger sentence? And the second part of my sentence is, does the actuarial life expectancy matter if the 15-year-old in prison is not expected to live past the age of, say, 56, as I think Judge Posner has cited?
Yes, Justice Wilson, I will answer your question. I'm going to finish first, Justice Rosen, to your second question, and whether or not the district court made some kind of an assumption here. I would respectfully disagree. At record volume 11, pages 17 to 18, the court explicitly says, well, considering all the required factors, the judgment, order, and sentence of the court will be as follows. I do have to say I find these crimes particularly disturbing. And there's lack of a word for it. And I really have a lack of words to say anything beyond that, especially from a young man like Mr. Gulley, that is an intelligent young man with so much potential that he has chosen this path in life. And then he proceeds to impose the sentence. So I think that there is a legitimate and valid exercise of discretion here. That is bolstered by the fact that the district court exercised its discretion to stack the additional aggravated robbery sentence on in a consecutive manner. The court did consider this juvenile and his history and whatever factors were necessary. Justice Wilson, as far as 60 versus 15, no, I don't think that it makes a difference. The sentence should fit the crime, and that should be true regardless of the age of the defendant. Now, asking about actuarial life expectancies, things like that, I guess I would return to what I noted in my brief, and that being that these kinds of inquiries, these kinds of questions are realistically, those are ones that are better suited for the legislature, with all due respect to this court. The United States Supreme Court recognized in Jones that states can choose to enact policies to provide protections greater than that provided by the Eighth Amendment. But notably, every one of those policies has been a legislative act. Every one of the policies that's been approved has been a legislative act. Those kinds of questions of public policy are for the legislature, not for this court. Again, with all due respect, because we're talking about potentially massive amounts of evidence, actuarial analysis, and how far do we go? One of the main goals of the Kansas Sentencing Guidelines Act and the Constitution, for that matter, is to individualize a sentence so that the punishment fits the crime. How far do we go? Does a defendant have to submit to a full health exam? And we have to have medical documentation about how long they live? Do we need to take into consideration their dietary requirements, their educational opportunities while incarcerated? It becomes a bit of a not only difficult, if not impossible, task for this court to undertake, particularly in this case, given the manner in which this issue has been raised. But it's one that's subject to far more inquiry, that is better suited for the legislature. Again, here, I think that the statute that the district court applied here did give it the necessary discretion that's required by Jones. The district court exercised that discretion. And because it did so, the defendants.
Well, what discretion did the court have? According to according to you, Mr. Gillette, once you're in the grid box, 618 months is the sentence. Where's the discretion? Where's the opportunity to even consider any other factors once you're there? I didn't hear you say that there was.
The discretion, Your Honor, that I would point out is that the discretion is actually between 600 and 618 months. It is narrow discretion. I do not dispute that. But this court has regularly found
you're just, so that's just a matter of, I mean, there's no statutory guidance for that conclusion, Mr. Gillette. You're just utilizing some interpretation that once you're in the grid box, you can't go below 600 months, but there's nothing that says that. In fact, it says you impose the appropriate sentence in the grid box is what it says.
Well, and I think that was my point, that it would be a reasonable interpretation, because the intent of the statute is to not have individuals with significant violent criminal history to receive a sentence of less than the hard 50. And then as far as the range from 600 to 618, this court has regularly held that any number within the given range in the grid box would be a presumptive sentence.
So basically what you're saying, the Miller factors just don't come into play here at all, period.
Correct. This court had the opportunity to exercise its discretion.
So once you have between like an 18-month discretionary period, Miller factors go out the window. It doesn't matter age or any of those factors. Doesn't matter.
I agree. I think that's correct. Based on Jones, I don't think that it matters, as long as there's opportunity for discretion here. And I would return also to some of the questions about the MAP process. And I think that is an absolutely important consideration for this court. The MAP process here is invaluable. The MAP process here in Kansas, based on our statutes, provides all of the protections Miller requires, even if they're applicable here. And as far as the record in this case demonstrates, I think it's valuable to remind the court that the district court, before it could even consider the potential range of sentences should defendant be convicted of some crime, knowing full well that he would not be convicted necessarily of premeditated murder, but it was a possibility. But any lesser could have also been a possibility. Notably here, though, this district court did hear the MAP process and received a full psychological report, including that within that report, it explained this clinician has a concern for risk to public safety. It goes on, defendant has a lack of accountability and has repeatedly engaged in violent attacks against others, including authority figures. He is of high risk for additional aggressive behaviors.
Is there any indication other than the map? The map proceeding basically focused, it was almost entirely focused on the crime, whether it was committed, the nature of the crime. I mean, there's 2 transcripts. It's full of references to the crime, very little reference to the psychological evidence. There's some, I grant you that. But that was even before a different court and a different judge. Does that matter?
I don't think that it does here. I would also note that the court was able to not only review that psychological report, it heard from the defendant's mother, who described him as regularly leaving the house and trying to act as an adult. And that was her own evaluation of him and his behavior. But the district court could easily take judicial notice of the things here. And if there needed to be something more clear, I don't know that that's necessary. One final point, if I may, Chief, I see that I'm out of time.
Yes.
I acknowledge that Miller versus Alabama sought to undermine or point out that the MAP procedures that were at issue in those cases were insufficient. But here we are different. Our MAP process is far broader. The judge in this case, and the judges of the court, knew virtually everything that they were going to know about the facts of this case. Everything that was presented later just bolstered what the district court knew before granting the motion for adult prosecution here. It knew about the offender, the nature of the offense, and the nature of the defendant's own mind. And while the amount of discretion here, again, is narrow, it's not as easy to describe this court having to make an incredibly difficult choice between a lengthy adult sentence or the juvenile sentence. We had a 15-year-old that could have been treated either in the juvenile system until he's 21, as EJJP until he's 23. So we're talking about 96 months, roughly 8 years, or he could have gone to the adult system where his sentence could range widely depending on what he was convicted on. And I guess I would wrap up by noting that given all of that, as Justice Steele asked, the United States Supreme Court has indicated before that in Lockyer versus Andrade, that's referenced in Graham and was brought up in the Williams case, a hard 50 is materially distinguishable from a life without parole term. And that's true even when the defendant wasn't going to get out of prison until he was 87. So I think that our hard 50 satisfy, even if the sentence here complies with the 8th Amendment, any requirements of Miller and Jones. But even if those protections necessarily applied, that there's nothing unconstitutional about defendant's sentence in this case. And if there are no other questions, I know I'm well out of time. I appreciate your consideration today.
Let me just ask Mr. Gillette one last question, if I might. Does Jones define the type of discretionary sentencing scheme that the court intended to carve out?
No, I don't think that there is a set definition, and I appreciate that opposing counsel wants to try to craft one based on some ambiguous, meaningful opportunity at life outside of prison. But this leans right back into a legislative question. What on earth does a meaningful life mean? Is it a day, a week, a moment, a decade? It's an ambiguous question that is frankly impossible for this court to define, certainly based on the record in this case. Thank you, Your Honors.
Thank you, Mr. Gillette. Mr. Nowak, you reserve 3 minutes.
Thank you. I'd like to start and briefly address counsel's Lockyer argument. What we know from Roper, Graham, Miller, Montgomery, and Jones is that juveniles, children, are constitutionally different from adults for sentencing purposes. Lockyer did not purport to apply to juvenile sentencings. Miller Court essentially addressed this exact same argument when it came to Berlimer, which held that a sentence does not become constitutionally disproportionate just because it is mandatory. And they applied the exact opposite, and they had the exact opposite holding in Miller, because children are different. They said we are not allowed to treat them as miniature adults. And in fact, it will be the odd law that does not have an exception for children. So respectfully, it's our position that Lockyer has little to no applicability to the question at hand. In regards to whether or not the judge actually considered Emond's youth and attendant characteristics at sentencing, he didn't, not in any meaningful way at least. To do so, he would have had to have found KSA 216620C1B unconstitutional. And he did not sua sponte find that statute unconstitutional so that he could take a meaningful review of Emond's youth, attendant characteristics, his individual circumstances before imposing a sentence. Simply said some nice words before he imposed that sentence. And that is problematic because, again, everything we know from Roper all the way to Jones is that juveniles, their attendant characteristics, their intrinsic traits, those make them constitutionally different. Those make that fact is substantial as a matter of law. And our law needs to allow for the sentencer to determine whether or not it's compelling in an individual case on an individual circumstance. If there are no further questions.
Yeah, once you get there, explain to me what the court is to do on a remand in your scenario.
The court is to do on a remand in our scenario. It's our position that if this court were to find KSA 216620C1B unconstitutional, it could find that to be, or as applied to juveniles, it could still subject Emond to resentencing on that statute as a whole, just not the mandatory provision, which places him in a sentencing discretion of hard 50 or a hard 25. Now, I do have some issues with the way this court has clarified substantial and compelling as it pertains to juveniles. I think that any court that says that there are no substantial reasons when you're dealing with a juvenile in this case, that's an error of law. I think we have to have it be substantial as a matter of law, and the court is willing to make that, able to make that determination if it's compelling. Absolute discretion between those two sentencing ranges, I think that is perfectly acceptable under Miller.
Do you agree with Mr. Gillette that the court only had discretion between 600 months and 618 months?
I think that is a reasonable interpretation. I also think a reasonable interpretation is the entire range. But frankly, if we're trying to find a non-absurd interpretation, it is likely between 618 and 600 months, the sentencing range. If there are no further questions, ask to submit issues 2 and 3 on the briefing, ask this court to reverse Emond's conviction or alternatively reverse his sentence and remand for resentencing. And I thank you for your time.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. We are now in